That was question 2. Question 1 was, when do I qualify? So question 2 is, what are the benefits? And question 3 is, where do I go to get those benefits that we just talked about? This is probably the most misunderstood provision of the law, and maybe sounds a bit like the craziest provision that you could find in law. And let me give you 3 hypotheticals, and they're each separate, but just consider 3 circumstances. One is that you are driving down the road and a drunk person crosses the center line and hits you head on. That's circumstance number 1. Number 2 circumstance is you are a passenger in your son's vehicle and he loses control and hits a tree. The third consideration is you leave your car in your driveway at your house at home, and you are walking down the street in Traverse City shopping for candy cane, and you get hit by a runaway bus. The question in all 3 of those circumstances would be, those people were injured in an automobile accident, where do they go in order to get coverage, the benefits that we just talked about? The odd thing about the Act is that each of those people in 3 different circumstances all go to their own insurance company on their own vehicle. Whether that vehicle is at home in the garage and you're walking as a pedestrian and get hit by somebody else's car, whether you are a passenger in a car, your son or anybody else's, or whether you're driving down the road and somebody else is completely at fault. In the drunk crosses the center line provision, or the piece, the person, if you are injured in the auto accident, you would go to your own insurance company, and the fellow who caused the accident would go to his own insurance company for the benefits that we just talked about. In the circumstance where you are a passenger in another vehicle and there's an accident, no matter who caused it, you as the passenger in the vehicle would still go to your own insurance company on your vehicle, even though your vehicle wasn't involved. The third one is you are hit as a pedestrian with your car at home in your garage. Still, the very, very same thing. You would go to the insurance company on your own automobile insurance, for your own automobile insurance on your own car. It's a little more complicated than that. It's a little more expansive than that, because in all of those circumstances, and again, this is in the provisions that are provided to you, but in all of those circumstances, assume for a moment that you did not own an automobile and you therefore did not have independent automobile insurance. Under all of those circumstances, you still would then, the next step along the way is, do you live with someone who's a relative and they have insurance? If they have insurance, it's one step removed, but if they have insurance, then in each of those circumstances, the person would end up going to the insurance company for what is called the resident relative. After that, there are varying steps. If they don't have insurance, there's another step. And if these folks don't have insurance, there's another step after that. And there's a final step that you would end up with what is called the assigned claims fund. All of that is available and it comes into play as long as you are not driving an owned, uninsured vehicle. If you are, you have no rights. If you have a vehicle that is insured and is involved in the accident, then you have all the rights and all the priorities all the way down that list. I guess in one fell swoop term, if you're involved in a motor vehicle accident and you're injured, I guess the only thing that you would really have to remember is go home first. Go to your home first, which means your insurance carrier if not yours, the insurance carrier of a resident relative with whom you live. So go home first, and that's kind of that probably applies to 85% of these circumstances, because most people actually do drive vehicles and have insured vehicles. As a miscellaneous consideration, let me talk a little bit about the process. If you're in an automobile accident, no matter whether you're at fault or not, and I reiterate that because there's a lot of misunderstanding about the no-fault benefits. Whether you're at fault or not, if you're in an automobile accident, you encounter a medical expense, or you encounter a wage loss, or you have somebody assist you in some fashion as a replacement service, or any of the benefits that are available under the No Fault Act, you have 1 year from the date of the accident in order to submit what is called an application for no fault benefits. The application for no fault benefits can be acquired by calling your insurance agent, the insurance company, if you have a line to them. Quite frankly, most attorneys who handle this kind of law have these forms. I have generic forms that we use to send in so there's the 1 year statute, it's called a 1 year statute of limitations. The 1 year statute of limitations under the No Fault Act actually has two parts to it, however. Part one is that you have 1 year during which to file the application. The application is not terribly complicated, unlike most things. It's what's your name, were you in an accident, what car do you have insured with us, how were you injured, sign it and send it in. That part of the statute is then taken care of. The second part of the statute is something that kind of moves along in time. When I say moves along in time, it's still a 1 year provision. But once the application is in, you move to the second part. The second part is that you have 1 year from the date that you encounter a medical bill to submit that bill to the insurance company. So you have an accident on January 1st, and 6 months later,